Hello and welcome. I am going to go over how to transfer your bank and your financial assets into your trust. My name is Ali. I'm the owner and founder of Goff Legal. If you're a client, you've probably heard this before, but go ahead and watch the video again. No times too many. We're happy to share this information. And if you're not a client, well, then you should probably have heard this. But if not, this is great information for you. So, in order for a trust to work, there need to be assets in it. And one of those things that we recommend that clients often put into their trust are bank and financial institutions, financial accounts, meaning brokerage, stocks, bonds, money markets, checking, savings, cash accounts, investment accounts. This is distinguished from retirement accounts, which is a different video. So this is only about cash and cash-like assets in a post-tax account, meaning taxes have already been paid on it. It's a standard brokerage investment type account. You will need a couple of things. So let's start with bank accounts. You're going to need the certification of trust that we provided for you in your binder. It outlines the information that the bank needs to transfer your accounts into trust, namely the name of the trust, the date of the trust. Is it revocable? What's the tax ID number? Who are the trustees? Who are the successor trustees? Do you have authority to place that asset into the trust? All of that is on the certification of trust. And what will happen is you'll walk in and say, "Hi, I have an appointment." Usually you should make an appointment because it'll make your life easier. "Hi, I have an appointment to transfer my accounts into trust." And they'll say something like, "We need documentation. We need a copy of the trust." You'll go, "No, you don't. Here's my certification. This is an abstract. This is the information you need to transfer my accounts into trust." If they know what they're doing, they'll be like, "Cool, this looks great." Sometimes they will hand you a form that says certification of trust. And you'll sit there and you'll go, copy the information from your certification onto their form and sign it for them. That's fine. I wouldn't argue with them. I would just go ahead and follow the process because it's going to be easier than fighting with them over what that looks like. And that's it, right? Once you have transferred that checking account or that bank, whatever account, savings account into the trust, the statement, the next time it's generated, will say your name's trustee of the name of your trust dated, or TTE or TR or UTD. All those things indicate that it's in the trust. So that's what you need to know, is to make sure that when you're done with this, the accounts are named in the name of the trust. The title of your checks don't matter. You can leave your checks however you want. Doesn't really matter. It doesn't. But the account statements do matter. Here's two things you should also know about funding your accounts. One, oftentimes institutions will try and get you to open new accounts. Two options. One, don't, because all of your stuff is auto pay, and see if you can negotiate with them to not do that, because it's a pain to redo all of that. Worst case, let's say they won't do it and you don't want to move banks. By the way, you could just threaten to move banks and I'll find you one that will accept it and put it into trust for you. But if you don't want to move banks, you can name the trust as a beneficiary of the account. This happens when you don't have the owner of the account present. Let's say you have a joint account with a sibling of yours or a parent of yours or a child of yours. You can't just take that account and put it into trust without their permission because it's part of their account. But if you want to make sure that after the last owner of the account dies, it goes somewhere, the trust can be listed as a beneficiary. Oftentimes, credit unions are particularly difficult, and you can name them as a beneficiary. It will still work. It's a little annoying, but it's not the end of the world. And that's still funding. It still counts, right? Whether you put it in the trust or list it as a beneficiary, on your death, that account will go, well, sorry, on the death of the final owner of the account, it will go into trust, your trust, and avoid probate, because that's the goal. So certification of trust is key for those sorts of things. Investment accounts are basically the same thing, though a lot of them, all by the way, you can find online. There's online forms. If you have a financial planner or advisor, call them and make them do this for you. That's their job. They're great at it. They're fast at it. They probably have a team that will support you in getting this taken care of. Make sure that those accounts are in the name of your trust so that if you're incapacitated or you pass away, the next trustee can contact them and say, "Hi, certification of trust. I am the trustee please give me access to the account. The account people say, oh, thank you so much. Let me grab some information. The account is now in your name. You can transact business as the trustee and manage those assets and do what you're supposed to do with them. So that's the information on how to fund bank accounts and investment accounts into your trust. Oh, by the way, which ones you should put in trust or not is a lawyer question. If you work with us, you'll look at your asset roadmap that says where your stuff is supposed to go, or you'll call our office and say, can you please remind me where this thing goes? If you're not sure, contact your attorney to find out, because not all accounts should go in your trust. Not all accounts should have beneficiaries depending on how they are. Please, please, please talk to your attorney about that before you start making changes if you're not sure what you should be doing. Okay, that's all. If you have questions for my office, you know our information. You can also find it at gofflegal.com.